Consequently, it is also stated that the object of the police service is to prevent, combat, and investigate crime, to maintain public order, to protect and secure the inhabitants of the Republic and their property, and to uphold and enforce the law. That is the ambit of the authority of the accused before court. The accused abused in an extremely egregious manner, even cavalier to state manner. They took state property, utilized the cars, the docket, utilized manpower of the state by the gentleman who was driving the other car. When accused number one was the passenger, he was not called as a witness. And they went and invaded the privacy and life of Alice. This was the taking of the law into their hands. They acted illegally, unlawfully, and with no factual, objective, reasonable reason whatsoever, to use the tautology. These courts even before pre-constitutional era regarded transgression by the police in a very serious light, because these are the guardians of peace and stability in the country. Now, if the police themselves are going to transgress the law egregiously, the courts look down on this conduct. I mean, as far as even 1997, in the case which was quoted by Mr. Van Zyl, W.D. Force and Andre versus the state. This is what Judge Praise had to say. Quoting the case of R versus Faucheux, 1958, 2SA, 268, 2646E, de Villiers at 246C said the following: assaults by the police on prisoners or suspects. Now, Alice Manana was not even a suspect, he was not even a prisoner. Cannot be tolerated where such assaults are for purposes of obtaining confessions or admissions or information. This is what the two accused wanted from Alice Manana. They are doubly objectionable as being the worst form of degree methods. Small Beggars had this to say in S versus Krilling and another. (1993) 2495. The police operate under difficult and often dangerous conditions. It is understandable that given the pressures and circumstances of their work, a lack of cooperation on the part of a suspect can lead to frustration. But with the wide powers of arrest and attention enjoyed by the police come a concomitant responsibility. They are in keeping with their training, required to act throughout in a disciplined and professional manner with due regard to the rights of citizens, and in particular, those in their custody. Every suspect, you can even read, every person has a fundamental right to remain silent if he so wishes or chooses. And no police may be committed or encouraged to extract information from a suspect by unlawful and least of all violent means. This is what accused number 1 and 2 did. They extracted information from Alice Manana by violent, illegal, egregious means. And as a result, despite the protestations that she had to look after her child, get somebody to look after a 5-year child. They told him, no, we don't have time to waste. After misrepresenting the police image and unlawfully stating that they were investigating a charge of kidnapping, and that the investigating officer, apparently the arresting officer, is accused number 1 and the complainant is accused number 2. She was taken against her will, as I say, and detained against her will. By persons who were on a frolic of their own. And in this matter, it is revealing that because of ignorance, and I'm not saying this intemperately, legal ignorance, neither Sophie Ramokhibe nor the sisters of Ramokhibe Oupa, nor Alice Manana herself sued the state for unlawful detention. It was not even an arrest. It was an unlawful detention which has consequences for the state. But because they were dealing with persons who are not lettered in the law, it was left begging. Okay, we'll continue tomorrow. Because I'm told they've got to be out at 4, is it? The prisoners.
That's good.
Okay, can you adjourn until 4 tomorrow morning?
As a court, please.
As a court, please. Until what time?